So this is the 3 a.m. DUI series. This is video number 5, and this is a video specifically for the Oregon drivers who get a DUI in the state of Washington. My name is Andrew Wheeler. I've been a criminal defense attorney now for the last 14 years in Southwest Washington, and for the last 12 years I've focused my practice on DUI defense. Every year I would say about 15% of my drivers are out-of-state drivers, and as you can imagine, being located here in Southwest Washington, a majority of those drivers are licensed in the state of Oregon. The first thing I hear from a driver when they come in is they're giving me certainly their citation and their breath test form, and they kind of push across the Department of Licensing paperwork and say, well, I probably won't be needing this. I'm not licensed in the state of Washington. And the first thing I tell the client is that Oregon and Washington have what's called direct reciprocity. And what that basically means in a very fancy way is the states communicate with one another and they honor what the other state does. The sense is that the Oregon driver absolutely has to act as if they are a Washington driver in terms of requesting that Department of Licensing hearing. The timeframes are that the hearing request has to be mailed out within the first 20 days from the incident date, not the first court date, but the date of the actual incident. For folks that retain our services, we do this mailing for them. We do certified return receipt mail near the end of the process. The burdens then shift to the Department of Licensing. They have to have a first scheduled hearing within the first 60 days, 10 days notice prior to that hearing. And if you have counsel, you can do a one-time continuance out to the 90th day. Now, video number 6 in our series is going to go into great depth talking about the Department of Licensing hearing, but suffice it to say for right now, the hearings officer during that hearing can make only one of two decisions. Number one, they can decide to dismiss the action. Great, wonderful, we won. The other option they have is to sustain the action of the department, and that means that you didn't win. Now, the sense at that point is that initially nothing happens because we have to understand two key words. The state of Washington can suspend a person's privilege to drive in Washington, but it cannot invalidate the Oregon license right away. Now, a few of you probably just had a sigh of relief, but it doesn't mean Washington can't act on the Oregon license overall. It just means it's a bit delayed. For the first 30 days after the incident, my Oregon drivers are in a status with what I call the Jansen Beach rule. What that means is if you stay south of Jansen Beach, you're perfectly fine to drive. But if you cross into the state of Washington where your privilege to drive is suspended at that point, you're actually suspended in the second degree. Now, at the end of those 30 days, Oregon is going to make a communication out to its driver based on what Washington sends them. So Washington and Oregon are part of what's called the National Registry, and that's a series of 48 states who communicate license information between one another. Washington will then send a notice to Oregon, and Oregon then will send a notice out to its driver. So what happens is, if you think about your driver's license as an Oregon driver, every morning the state of Oregon wakes up and looking out at the 47 other states. As long as none of those states have a red flag up, everything's fine for the Oregon driver that day. Right after day 30, though, from the administrative action, Washington has a little flag up in the air. Now, pre-2014, the state of Oregon used to yell across the river to Washington and say, "Hey, Washington, why's your flag up?" And Washington would say it was a DUI action, and Oregon then would act accordingly, meaning Oregon would say, let's pretend this driver got a DUI in Oregon, and in that circumstance, let's grant them a hardship license. And that was a very fair process. The problem is post-2014, because now instead of yelling across the river to the state of Washington, Oregon just says, hey, there's a problem in Washington, and they send out a form letter. The form letter says you may have been in a traffic accident. It says you may have got a traffic infraction. But it says you have only 15 days to clear up whatever the problem was. And the problem is the driver can't clear this up because it's a DOL administrative action. The important thing to understand is that any DUI action received by the state of Oregon is going to have a 1-year suspension. But all suspensions aren't created equal. So in the state of Washington, a person who blows just over a .08 but under a .15 has only a 90-day suspension. And in that circumstance, I can run for my clients about 45 days of that time frame before Oregon ever takes action. But during those last 45 days, we have what's called a blackout period, meaning the Oregon driver cannot drive at all. They cannot secure a hardship license because Oregon perceives that circumstance as being what we call an out-of-state hold. In a circumstance where my Washington action results in a breath test of over .15, now that's a 1-year suspension. What that creates in that circumstance is over 10.5 months that Oregon driver cannot lawfully operate a vehicle in the state of Oregon. In a worst case scenario, there's both a criminal conviction of a DUI refusal and an administrative action, and this can be a blackout period for almost 2 years. So the circumstance is, as an Oregon driver, it's important to understand that at the very outset, it's important to talk to a Washington DUI defense attorney, number one. Number two, it's important to understand that even though you're not licensed in the state of Washington, you still have to request that administrative hearing within 20 days of incident. The last thing I want to really briefly talk about is what we call an out-of-state IIL. And this is what came about within about the last year and a half. And it was a circumstance where we believed the state of Washington was going to grant out-of-state drivers an ability to keep their license. This didn't come to pass because the state of Washington did not talk to Oregon, it did not talk to Idaho, and so it created what I call the canoe law. And the canoe law is a circumstance where the Oregon driver, if they somehow were to canoe across the Columbia River, could then get in a vehicle in Washington and drive under what's called the IIL. Now, as you can imagine, this isn't practical whatsoever because the Oregon driver cannot drive in their state of licensing, they can't get to and from work. This is not indeed what the law was intended to do. So I hope you found some value today in our discussion of Oregon drivers with DUIs in the state of Washington. And again, please give me a call if I can be of any further assistance. Thank you.